Is Georgia a community property state? Determining how property is divided in a divorce can be a complex and often contentious process. Many people wonder if Georgia is a community property state, as this distinction significantly impacts the distribution of assets. In community property states, marital property is typically divided equally between spouses. However, Georgia follows the principle of equitable distribution, meaning that property is divided fairly, though not necessarily equally. Understanding these differences is crucial for anyone navigating a divorce in Georgia, as it helps set realistic expectations and prepare for the legal proceedings ahead. Legalities of property division in Georgia. Georgia is not a community property state. Instead, Georgia divorce laws give both spouses an equitable interest in all property acquired during the marriage. This method, known as equitable distribution, aims to protect the interests of both parties and ensure that each spouse has the resources they need to move forward after the divorce. Equitable distribution allows the court to divide marital property fairly by considering various factors such as the length of the marriage, the financial and non-financial contributions of each spouse, and the economic circumstances of both parties. The court has the discretion to award a larger share of the marital property to one spouse if it deems it just and reasonable based on the presented evidence. This method aims to achieve a balanced outcome that considers the future financial stability and well-being of both spouses, rather than strictly adhering to a 50-50 split. Definition and process of equitable distribution in Georgia. Marital versus separate property. Understanding the distinction between marital and separate property is crucial in Georgia, as it influences the division process. Marital property refers to assets acquired during the marriage, while separate property includes assets owned before the marriage or acquired individually through gifts or inheritance. Marital property in Georgia includes all assets and property acquired by either spouse during the marriage, regardless of how the property is titled. Examples include real estate, homes and land purchased during the marriage, vehicles, cars, trucks, and other vehicles acquired while married, income, earnings from employment and investments during the marriage, financial accounts, joint bank accounts, stocks, bonds, and retirement accounts like 401ks. Personal property, furniture, jewelry, and other personal items acquired during the marriage. Separate property consists of assets that belong exclusively to one spouse, typically acquired before the marriage or through specific means during the marriage. Types include premarital property, assets owned by either spouse before the marriage. Gifts and inheritances, property received by one spouse as a gift or inheritance, even if received during the marriage, is considered separate. Agreed separate property, items that both spouses agree to classify as separate property. Determining marital and separate property. Determining whether the property is marital or separate can be complex and requires careful examination of each asset's acquisition and use. Key considerations include documentation and records. Financial records, titles, deeds, and other documents are reviewed to trace the origin and ownership of assets. These documents provide a clear history of when and how an asset was acquired, helping to establish whether it is marital or separate property. Commingling of assets. When separate property is mixed with marital property, it can become difficult to distinguish and may be reclassified as marital property. For instance, if a spouse deposits an inheritance into a joint bank account used for marital expenses, the funds may be considered commingled and thus part of the marital estate. Similarly, adding a spouse's name to a previously owned separate property, such as a house, can transform it into marital property. Transmutation. This is the process by which separate property transforms into marital property due to the actions of the spouses. For example, using separate funds to pay for improvements on a marital home or combining separate assets with marital ones can result in those funds or assets being considered marital property. Courts will look at the intent behind these actions and whether there was a clear effort to merge the separate and marital assets. Understanding the distinction between community property and equitable distribution is essential when going through a divorce in Georgia. The state's equitable distribution laws strive to ensure a fair allocation of assets and debts, considering the unique circumstances of each case. By familiarizing yourself with these principles, you can better prepare for the legal process and protect your interests. For personalized assistance and experienced legal advice, Reach out to the Marietta divorce lawyers at Tori Legal Group. Our dedicated team is here to support you through every step of your divorce, helping you achieve a fair and equitable outcome. Contact us today at 770-744-1529 or visit us at 274 Washington Avenue Northeast, Marietta, Georgia 30060, United States to schedule a consultation and take control of your future.